Well, good afternoon, everyone. Thank you so much for being with us today on this auspicious occasion, which we kick off the 2017 Historical Presidency Lecture Series here at the Miller Center. We run these through calendar years, so you will note that we have 3 for the spring semester, and we have 2 in our brochure for the fall semester. We have this spring semester 3, and for next fall semester we have 2 in the brochure, and we have 1 more that we're adding to that, Melody Barnes, who is a senior fellow with us. Could we have chosen a more timely topic than to talk about the President and the Constitution? I can remember Bill and I talking about this back last winter. Stephanie Georgakakis Abbott, my wonderful colleague who's helped to put this program together, and at the time we said, well, that's always an interesting topic, and this will also kick off our presidency and studies, the whole concept really, and we really want to focus on the President and the Constitution. And then we would add a footnote in our conversation, and we'd say, if we started in February, it'll be right after the new president is elected. And then we'd usually say, with a little bit of a grin, oh, and if it's Donald Trump, it will be even more interesting. And then usually someone would say, oh, just kidding, or no, that'll never happen, except for my colleague Howard Witt, who predicted that Donald Trump would win. So we just think that this is perfect because, again, who could have imagined, even if you did imagine a Trump presidency, that most of the categories under President and Congress would be inspired in the first 12 days of his presidency. So to talk about presidential power and executive orders and Supreme Court appointments and judicial interpretations of executive power, we have the perfect person with us today to do that. Before I introduce Sai to you, though, I just hope that you will join us on March 30th. That is our next date that we have been able to pin down for Joanne Freeman, a historian from Yale who will lecture on founding presidents. She is to become part of the NPR backstory team with our own Brian Ballow, so we're really excited to have her coming on March the 30th. And then on April 11th, to round out our spring semester program, will be my colleague Russell Riley. He and I co-chair the Presidential Oral History program here, and he's going to speak on what happens to presidential power in post-war presidencies. So today, let me have the honor of introducing to you Sai Prakash. He is the James Monroe Distinguished Professor of Law here at the University of Virginia Law School. Sai earned his BA from Stanford University, where he was a double major in economics and political science. He then earned his law degree from Yale University and was senior editor of the Yale Law Journal. From there, he went on to clerk for Judge Lawrence Silberman of the D.C. Court of Appeals, and then from there to clerk for Clarence Thomas at the U.S. Supreme Court. Here at the law school, Sai teaches constitutional law, foreign relations law, and particularly for our topic today and for our current president, presidential powers. He has published in many law reviews across the country, particularly in the Yale Law Journal, the Michigan Law Review, and the Virginia Law Review. His book is titled Imperial from the Beginning. So that's the beginning of his title, Imperial from the Beginning, the Constitution of the Original Executive. That was published by Yale University Press in 2015. But my favorite title that he has applied to one of his law review articles is the Imbecilic Executive. And last night when I was reminded of that, I thought, I think of imbecilic as being foolish or stupid, and so perhaps there's another meaning, and I went back and looked up imbecilic, and sure enough, it's from the Old French, meaning weak or enfeebled. And so that was how Sai was using it to apply to the presidency and to presidential powers. And finally, he has been, I'm sure, bombarded by the media, particularly in the last week. And one of the topics that he has spoken on to the media is why Trump's executive orders worry some conservatives, which is a really interesting way to look at that topic. So Sai will speak to us for about 40 minutes or so on this topic topic of executive power in the presidency, using all of his knowledge that goes back to the founders and the founders' intentions, and then how presidential power has evolved over time in the 200 plus years of our constitutional system. And then Bill Antholis, the director of the Miller Center, who has inspired this topic, will ask questions of Sai and discuss the topic and then open it up to you. So thank you again for being here, and we hope that you enjoy this lecture.
Well, thank you so much for that wonderful introduction, and thank you all for coming today. I know you have busy schedules and busy things going in your life, and I'm gratified that you've taken the time to come here. The title of my talk is The President's Power to Amend the Constitution. Before I get into the talk, I want to put a plug in for the book, right? It's available at Amazon and other fine retailers. And I'll give you a thumbnail sketch of the book, because I'm actually not going to talk about the book today. I'm happy to talk about it in the Q&A, but that's not the topic of my talk today. The book is a sort of soup to nuts consideration of the original presidency, the antecedents of the presidency, the various structural features of the presidency, like one president, no council, being able to serve multiple terms, a guaranteed salary, the powers of the presidency, right? The power to pardon, the executive power under the vesting clause, the power to appoint, the power to nominate, commander-in-chief. And so there are 13 chapters, and it just sort of goes through each of these questions in a sort of systematic way and gives you a sense of why the president was constructed the way it was and the contours of the original presidency early on. And the book's overall claim is the presidency was meant to be a powerful institution. People did not have illusions about it when they created it. They realized that it was more powerful than any extant American executive institution, right? It was more powerful than the state governors. It was more powerful than the Continental Congress in terms of executive authority. And it rivaled the crowned heads of Europe. Many people in America, many people in Europe said, you've got an executive called a president, but it really looks like a king to me, right? Jefferson said this, Adams said this, the stadtholder of the Netherlands said this, right? You've got he said this in French, you've got a president, but this person's really a king. And lots of anti-federalists said this, right? People opposed to the Constitution consistently said this executive is too strong. And there were reasons why they made the executive strong. They thought the state constitutions had weak executives and that they didn't serve as a good counterbalance to the state legislatures, and the state legislatures were running amok. And so they create this unitary executive. They granted a veto authority. They make it eligible to serve indefinite terms, right? The president can serve over and over again until they pass that amendment. The only reason why presidents don't is because of Washington's example, not anything in the Constitution. That example is broken by Roosevelt, and people quickly amend the Constitution. But the various features of the presidency conduce to the conclusion that the presidency was meant to be very powerful. Not all powerful by any means, but very powerful. What are some of the constraints I talk about here? One of the constraints is I think the president lacks an emergency power. And the article that Barbara mentioned, the Imbecilic Executive, is about that question. Does the president have the power to suspend habeas corpus, as Lincoln did? Does the president have the power to seize steel mills, as Truman did? And I argue no. The presidency is powerful, but it's not all powerful. Another chapter is on the war power, right? The president's commander-in-chief. Can the president take the nation to war? The modern answer seems to be yes. See Libya, right? See the Korean War. But the old answer under the original Constitution was no. The power to declare war was a power to decide whether to wage war. Presidents like Washington, Jefferson, Madison, Adams, they all understood this, and they all acted consistent with this. Right? Madison's message to Congress before the War of 1812 says, Great Britain is at war with the United States, we're at peace with them, you're going to have to decide what to do. He basically is saying, we're at war with Great Britain in the sense that they're attacking us, you've got to decide what to do. He never said, because they've attacked us, I'm going to wage war against them. And that's said repeatedly across early presidencies. And we see traces of this as late as World War II. Right? Japan attacks Pearl Harbor, formally declares war. President Roosevelt just doesn't say we're at war and now we're going to take it to the Japanese. There's a declaration of war, right? Congress weighs in. And Congress weighs in not once but 5 times. There are 5 declarations of war against the various Axis powers in World War II. So even though it's called Imperial from the beginning, right, The claim isn't that the president's all-powerful. The president has lots of authority. He just doesn't have all authority. And so he's a limited monarch, not an absolute monarch. He's more actually akin to the English monarch than he's akin to the French monarch of that era. Right? The French monarchy was thought to be absolutist, and the English monarch was thought to be limited by various statutory and statutory constraints and customs. And so that's the sort of thesis of the book. But there's more, and so I encourage you to go to your library or go to your bookstore and get it. So the title of my talk today is The President's Power to Amend the Constitution. It's meant to be provocative. The talk today has descriptive and normative elements. I don't know if I'm going to go 40 minutes, but I'm assuming that some of you will have questions about my talk. Maybe some of you might have some questions about the current occupant of the White House, and you know, maybe we can talk about that as well. Even if it has nothing to do with my talk, I'm happy to talk about that. So descriptively, I think the president is the single most important actor in terms of constitutional change, and I'll say why in a moment. And then normatively, I think this is not a bad thing. I think this makes sense. I think if we're going to have a living constitution, and I think if you look at our practice, we do, whether you think that's a good thing or not, it's not a bad idea to have the president in the driver's seat rather than to have the Supreme Court in the driver's seat. So let me describe the many ways in which the president moves constitutional law. And let me start off with formal amendments, right? When we think of changes in constitutional law, we think of formal amendments, and there have been 27 amendments of the Constitution, right? Formal amendments. Article 6 specifies that amendments can originate in the Congress when both chambers, by 2/3 votes in both chambers, want to propose an amendment to go to the states. They pass the same amendment by 2/3 majorities, and then it gets sent to the states. And the states have to ratify by, the legislatures have to ratify, 3/4 of the state legislatures have to ratify, right? Or 3/4 of the popular conventions have to ratify. Congress decides whether to send it to state legislatures or to send it to state popular conventions. That's the formal rule in Article 6, which specifies how amendments are made. There is no express role for the president in Article 6. But there's another clause called the Presentment Clause of Article 1. And Article 1, Section 7 says that every vote that requires both chambers, every action that requires bicameral action, must be presented to the president. Right? It's the basis for presentment to the president of bills and the president's chance to veto those bills. So even though Article 6 doesn't mention the president as having any role, Article 1, Section 7 tells us that every bicameral action before it takes effect has to be sent to the president. And so if you put the two clauses together, you might well have concluded that amendments have to go to the president for his signature or his veto. But long ago, this sort of understanding of Article 6 went by the boards, and it went by the boards almost immediately, right? Congress passes the Bill of Rights proposed by James Madison in the House. Those amendments aren't sent to the president for his signature, notwithstanding Article 1, Section 7. And so the very first 12 proposed amendments that go to the states don't get sent to the president first for his action. Instead, they get sent to him so that he will just send them on to the states. They're using him as a messenger, not as someone who has independent voice in whether or not those amendments get enacted. In 1798, in a case called Hollingsworth versus Virginia, Justice Samuel Chase of the Supreme Court at oral argument said, presidents have, quote, nothing to do with the proposition or adoption presidents have nothing to do with the proposition or adoption of amendments to the Constitution. So he seemed to be saying that presidents can't propose amendments, and presidents certainly have no role in their adoption. This changed with the 13th Amendment and an amendment that was proposed prior to that. So some of you may be familiar with the Corwin Amendment. The Corwin Amendment was considered on the eve of the Civil War, and it was designed to convince the South not to secede, and the amendment would have basically said that Congress has no authority to fiddle with slavery. All right, the idea was, we know that you're jittery Southern states. Let's pass this amendment that you like because you want to preserve the institution of slavery. And that was the Corwin Amendment. It got sent to Buchanan for his signature, the first time that happened. It also happened with respect to the 13th Amendment. That amendment got sent to Lincoln, and he signed it. But immediately after that happened, members of the House said this was a mistake. The president doesn't have any role in making amendments. and he shouldn't have been sent the amendment in that capacity. It's fine to send it to him to pass on to the the states, but he has no role in deciding whether to sign or veto this amendment. And pretty much ever since then, it's gone back to the sense that presidents have no role in vetoing, much less having the amendment presented to them by the House, right? And so we've got this formal process where the presidents don't play a role. Obviously today, I don't think anyone would say, as Chase said, that the president can't propose amendments. Anybody can propose amendments, right? You can write to your congressman or congresswoman and ask him or her to propose an amendment, and that's no less true for the president. But it's still sort of black letter constitutional law that amendments don't get sent to the president for his signature or his veto. So presidents don't seem to have a very robust role with respect to formal amendments. The more typical way that presidents affect constitutional law is through their appointments. And of course, we've seen a nomination last night from President Trump. I think presidents in modern times think about the judicial philosophy of their nominees, especially the Supreme Court. They ask themselves the questions: are these people living constitutionalists? Are they originalists? Do they favor a case like Roe versus Wade? Do they favor a case like Citizens United, which dealt with campaign finance? Do they sometimes do more? Of course they do more. You may be familiar with the court packing episode during the Franklin Roosevelt administration. Franklin Roosevelt thought he faced a hostile Supreme Court. And he could have done one of two things: wait until those people died or retired, or he could try to pack the court. And so he went to Congress and said, I've got this proposal. I'm going to suggest that we appoint new justices to the Supreme Court in a way that turns on the existing ages of the existing Supreme Court justices. That didn't go anywhere. But it's possible constitutionally to pack the court because the Constitution doesn't specify how many Supreme Court justices there will be. We've had, I think, anywhere from 5 to 11 Supreme Court justices over the 200 years. We've had 9 for a long time, but that's by statute, and Congress could change that. So you can imagine, right, if the Republicans don't like what the Supreme Court's doing, they say, fine, we're going to make Justice Sotomayor or Justice Ginsburg or whoever the justice is they don't like irrelevant by adding more people. That hasn't happened since Roosevelt, in part because people think there's something problematic about that. But that's not written in stone, right? People can, revisit those judgments over time and come to different conclusions. What is more common is sometimes people add judges to the lower courts, right? You might decide that the Ninth Circuit is too small, that there aren't enough judges on the Ninth Circuit to hear all the cases, or that the number of district judges in the Ninth Circuit or the Fourth Circuit or the Fifth Circuit is too low. And when you do that, you're basically injecting, presumably, a cohort of judges that reflect the president's philosophy, right? Because if a Republican-controlled Congress creates new judgeships during a Republican administration, that administration is going to fill those seats. And so, at least as an initial matter, you are certainly changing the composition of the lower federal courts when you create new judgeships that are immediately filled by the incumbent president. So court packing is a possible way for the president to affect constitutional law, the future trend of constitutional law. The most powerful type of court packing hasn't occurred in a long time, in part because of Roosevelt's failure, but nothing's to prevent it from happening going forward, right? Because the Constitution just doesn't say how many Supreme Court justices there are. It's always been done by statute. Let me talk about a third way that presidents change constitutional law, and that's jawboning, right? Jawboning. What do I mean by this? They plead their case in the court of public opinion and to the Supreme Court, right? You may recall that President Obama, in his State of the Union address several years ago, criticized the justices of the Supreme Court while they were sitting in front of him, right? He said that Citizens United was a wrong decision, and he characterized it in various ways. And you may recall that Justice Alito, in a moment of shock, said, which was not true. He said not true, not out loud, I don't think, but in a way that anybody, with any rudimentary lip-reading knowledge would know. That's what he was saying. And it was kind of like, wow, right? I mean, you're seeing sort of not open conflict. They didn't come to fisticuffs, but that's as close as you get in Washington these days. They don't tend to cane each other like they used to in the good old days. But that's a situation where the president is trying to tell the Supreme Court, you've done something wrong, right? You got the First Amendment wrong, and he's, I think, essentially trying to pressure them to to perhaps reconsider it going forward. President Roosevelt criticized the Supreme Court for having a horse and buggy definition of commerce. That wasn't a compliment, right? The claim was, you have a narrow understanding of the Commerce Clause. The Commerce Clause gives Congress lots of authority. You're trying to read it narrowly. That's wrong. Move into the 20th century. Jefferson, in private letters, likened the judiciary to sappers and miners. That's not a good thing, right? He was basically saying they were undermining the Constitution. I think sappers and miners are the guys who would dig under forts, put in explosives, and then blow up the forts, right? And he's basically saying judges are digging under the Constitution and blowing it up, right, through their decision making. And so presidents have done this, for quite a long time. They've criticized the courts, and I think, in some measure they might be doing it more publicly than they have in the past. I don't know if Jefferson said things like they're sappers and miners in public as opposed to private letters, but President Obama did it, and President Roosevelt did it as well. Does this affect justices? You might say no. They've got life tenure. They don't need to care about being called a sapper or a miner or having a horse and buggy whip. I mean, they could come to court with horse and buggy whips and mock the president. But they're people, right? And people respond to criticism, even if they've got life tenure, right? Professors have life tenure, but we're not impervious to criticism merely because we have life tenure. And I think lots of people understand this. I think President Obama understood this. I think President Roosevelt understood this. And I think the people who protest outside the Supreme Court occasionally understand this as well. They're not merely doing it for the cameras. I think they think that it might, in fact, affect what the court does. And you don't need to change the minds of 9 justices. You just need to change the mind of a few, right? Or have some influence on some justices on the margin, and that's all you may need to get what you want, right? If you can convince Justice Kennedy that this is a bad idea, whatever he's thinking about doing, then you will have an effect on his jurisprudence, even if you can't convince, Justice Alito or Justice Thomas, or Justice Breyer or Justice Ginsburg. So I've talked about amendments. I've talked about packing the courts. I've talked about job owning. My fourth category is executive creep, right? And what do I mean by that? It doesn't mean, I'm not referring to a noun, I don't think, right? I'm not referring to a person who is a creep. I'm talking about the notion that the executive can, over time, through practice, acquire new powers or change the way the Constitution is understood. And the Supreme Court has repeatedly said that practice matters in constitutional interpretation. The fact that it's been done this way for many years matters for whether this particular statute or this practice is constitutional. So in McCulloch versus Maryland, which is the Bank of the United States case, right, whether the Bank of the United States is constitutional, Marshall and the court said yes, but they said in the context of saying that, they said that practice, quote, ought to weigh heavily in separation of powers cases. It matters that we've had a bank for 15 or 20 years by the time we get to this case in a context where we're going to be upholding it. In another case about the pocket veto, an obscure provision of Article 2, the court said, quote, long settled and established practice is a consideration of great weight in a proper interpretation of constitutional provisions. And the most famous example of this in sort of semi-modern times is Felix Frankfurter in the Youngstown case. The Youngstown case, you probably have heard about it. It's about Truman's seizure of the steel mills during the Korean War. Truman seized these mills, saying that he needed to ensure the production of steel during the course of the Korean War. We need steel to win this war, he said, and I can't have these steel mills go on strike because labor and management can't sort out their problems. So he seizes them. He claims sort of constitutional or statutory authority. And the court says that's unconstitutional. The court says you don't have the authority. You don't have constitutional authority to seize the steel mills. You don't have statutory authority. And they decide that 6-3. There are multiple opinions explaining why the individual justices voted the way they did. Justice Felix Frankfurter is in the majority. He says that the president couldn't do this. But he says, and this is a famous quote from Frankfurter and from Youngstown, a systematic, unbroken executive practice long pursued to the knowledge of the Congress and never before questioned, engaged in by presidents who have also sworn to uphold the Constitution, making, as it were, such exercise of power part of the structure of our government, may be treated as a gloss on, quote, executive power, unquote, vested in the Constitution by Section 1 of Article 2. What does that mean? He's saying if you consistently do something over and over again, it kind of becomes part of the executive power. It becomes a gloss on what that phrase means in the vesting clause of Article 2. He says in that case, there was no systematic, unbroken executive practice long pursued by a president such that Truman could seize the steel mills. But he left open the possibility that if presidents had seized private property in this context 20 times before, it would have been constitutional. There just hadn't been that practice, he said, prior to what Truman had done. And so these are multiple cases where the court has told us practice matters. How does that matter for our purposes today? Well, presidents have, in some measure, slowly changed our understanding of various constitutional provisions through, executive creep, right? Sort of encroaching on other branches of the federal government, or perhaps encroaching on the Bill of Rights. So there was a case several years ago about the Recess Appointments Clause. It's a very obscure provision of the Constitution. But what it basically says is that the Senate, when the Senate's not in session, and a recess happens when the Senate's not in session, the president can appoint to offices. And the idea is, normally the Senate has to confirm, or consent rather, to a nomination before the appointment is made. But sometimes the Senate's not in session, and it's important to have the offices filled. And so when the Senate's not in session and the recess happens when they're not in session, the president can appoint. That had a very narrow understanding at the founding, right? It had a narrow understanding in multiple senses. First, they thought that the vacancy had to arise during a recess in order for that clause to apply. Meaning that if the vacancy arose while the Senate was in session, but the office remained unfulfilled when the Senate went into recess, the president wouldn't be able to appoint to the office during the recess. People follow what I'm saying? Okay, well, I'm not sure I followed what I said, so I'm impressed. And the second question was, well, what is a recess? Right? I can gavel the Senate closed every day. Is that the recess? Meaning the president can appoint people at 6 p.m.? No, no one thinks that, not even today. Originally, it meant the recess between sessions, right? If you study Congress, you know that Congress actually has sessions, right? The first session of the 72nd Congress, the second session of the 77th Congress, the third session of the 77th Congress. And so we number Congresses in 2-year increments, and within those increments, Congress decides how many sessions it's going to have. Theoretically, you could just have one session the whole 2 years. But they don't do that. They have the first session, the second session, the third session, sometimes 4 sessions. Originally, the Recess Appointments Clause only applied to those periods between those sessions, right? And so if you never had a recess and you only had one session over 2 years, you were just meeting continuously, there'd be no recess for purposes of the Recess Appointments Clause. If you had 3 sessions, you'd have, maybe, either, 2 or 3, right? Because you might have one at the end, right? You might have 3 sessions and then a recess at the end before the new Congress begins and a new session of Congress begins. But the point is, you didn't have anything like what is now called an intra-session recess, right? And what does that mean? Well, what the president eventually did is he said, look, you are having these sessions that last for months, but you are taking a 2-week break in between while maintaining the same session. If you're gone for 2 weeks, there are going to be vacancies that I think I have to fill. And I'm going to fill them during a recess that is not inter-session, but is intra-session. People follow what I'm saying? So that, again, was an expansion of the clause. And by the time of Nixon and Carter and Reagan, presidents were abusing this. Right? They were appointing people that the Senate refused to confirm. And they were appointing to offices that were, had been vacant for years, right? And where the vacancy didn't arise during a recess. The vacancy arose while the Senate was in session. The Senate refused to act upon the president's preferred nominee, or rejected them perhaps even. And the president said, well, I'm just going to go ahead and appoint someone now that you're not around here. And this really maddened some members of Congress. I think Ted Kennedy sued, arguing that it was unconstitutional. And it took Harry Reid to do something about it during the Bush administration. And what Harry Reid said is, we're going to meet every 3 days. We're going to gavel in the Senate, and then we're going to gavel it closed. And if we meet every 3 days, we don't think you can make any recess appointments. And by meet every 3 days, what I mean is there'll be one senator there, maybe two. The Senate won't be there. They won't be performing any functions. And that's what sort of, in part, killed the recess appointments clause, right? Because once he did that, the president didn't feel like he could make any recess appointments anymore, and he couldn't do the sort of shenanigans I'm talking about. And that tradition was carried over into the Obama administration, right? Because Washington is a tit-for-tat place, right? If it's good for Harry Reid, it's good for Mitch McConnell and good for Paul Ryan, et cetera. So that's the end of that story. But my point in raising that story is this recess appointments clause, which was originally thought to only cover vacancies that arose during a intersession recess, now covered any kind of vacancy that existed during any kind of recess other than we're going home for dinner recess, right? That's one example of presidential power creep, right? More authority going to the executive branch. And it's an example of the president just sort of consistently exercising that authority in such a way that outside observers would just say, look, the practice is you can do this because it's happened, right? How do we know that this can be done? Because it's been done thousands of times, right, by various presidents. And so when this case came before the Supreme Court, Noel Canning, a couple of years ago, Justice Breyer said, there's this practice, and it's a reasonable practice, and we're going to endorse the practice. The president still lost that case because he had this problem with the hammering in and hammering out. He tried to appoint someone when they were doing the Harry Reid trick, and the court took that as an actual session of the Senate and not a fake session. But that's after the court endorsed the notion that you can appoint people during an intra-session recess, and you can appoint to a vacancy that exists during a recess whenever that vacancy happened to come into being, right? We don't care if this office has been vacant for 10 years. If it is vacant during the recess, you get to appoint, and Breyer endorsed that view based on the practice of presidents sort of usurping or exercising that authority. Let me give you a better example that actually relates to the book, and I think war powers is the better example. I've told you that early presidents did not believe they could take the nation to war, that they went to Congress when they wanted to wage war. They thought they had authority to defend the borders of the United States, but they didn't think they had authority to engage in offensive operations against other countries. And they drew that distinction, right? Washington expressly draws that distinction. Jefferson expressly draws that distinction. And if you read the early comments about the Constitution, many people said the president can't take us to war. What happened was the presidents over 200 years have used force in many sort of small and large skirmishes. And so now if you go to the State Department, they have this document, and the OLC I think may now have this document, the Office of Legal Counsel in the Department of Justice, the sort of super lawyers of the executive branch. They've got a document of every time the president has used force overseas without a declaration of war. And they say, it's happened 200 times or 230 times. And then they say, if it's happened over and over again, it must be constitutional because we've put a gloss on the Constitution. We put a gloss on the executive power. They cite Frankfurter, right? And they cite McCulloch, and they cite all these cases saying, if you keep, the cases don't say if you keep on doing something unconstitutional, it becomes constitutional, because that sounds bad. But that's essentially what that means, right? If you think about it for a second, right? I don't mean that as a critique. I think that's what it has to mean, right? In other words, when Frankfurter's saying this, what he has to be saying is, I don't really care about whether it was constitutional before. If it happens enough time, we're putting a gloss on the Constitution. And that's a practical sort of understanding of what the Constitution is, right? And it has its pluses and it has its minuses. But that's the end result, right? And, even I've given you examples of presidential power where that's happened twice. Let me give you a third example, which is slightly different, right? I've given you the example of war initiation. There's now a view across our land that Congress can't micromanage the commander-in-chief. That is to say that Congress can't do certain things with the Army and Navy because that would be micromanagement, independent of whether or not it involves starting a war. And right, so some presidents say you can't do this to the Army or the Navy because I'm the commander-in-chief, and we don't have, this is often said, we don't have 535 commanders-in-chief. We have one. That's me, right? And you shouldn't be able to micromanage the armed forces in this way. But that itself is an alteration of the original practice. If you look at early statutes, they micromanaged the Army and the Navy in all kinds of ways, right? Specifying where they could be stationed, specifying where naval ships could patrol, specifying the proper targets in wars, right? You can attack some French ships, but not others. That's the quasi-war with France during the Adams administration. The War of 1812 came within one vote of being a naval war alone, right? Some people only wanted to have a naval war. I think it was in the Senate. It almost they were only willing to authorize a naval war, not a land war. That didn't work out, obviously, right? Because the War of 1812, the declaration of war, doesn't have such a limitation. But they thought they could do it because they had done that before, right? The war against Algiers and the wars against Tripoli had that provision in them, which they said this is a naval war. It's not a war where you're going to be using the Army. So they micromanaged the Army and the Navy, 6 ways till Sunday, if that's a phrase, and they didn't think there was a problem with it. And the commander-in-chief of the Continental Army, George Washington, and other people of that era, they signed these bills. They didn't say they were unconstitutional micromanagements of the Army and the Navy, and that's in part because Congress has broad authority over the Army and the Navy, right? Besides having the power to declare war, it says Congress can make rules for the government and regulation of the armed forces, and that's sweeping authority, right? It's not some minor grant. And so that's yet another example of what I would call presidential creep. And you can imagine this in other areas, right, with respect to rights, right? If the president consistently does something over and over again, he might erode a pre-existing conception of an individual right. It's harder for us to imagine that today because we have groups dedicated to preserving their particular sense of individual rights, and they are going to sue, right, in a way that's not possible oftentimes in war powers. But it's theoretically possible, right, that if you have a practice repeated enough times that someone like Frankfurter or someone of that bent will say, there's practice sort of helps liquidate the meaning of the Constitution, or at least puts a gloss, right, on executive power, on the First Amendment, on the freedom of free exercise of religion, etc. Let me mention one other thing that presidents can do to change our constitutional law. And I'm mentioning refusals to enforce and refusals to defend. Right? What do I mean by that? Well, some presidents refuse to enforce statutes that they believe are unconstitutional. Right? Jefferson was the first to do this. Jefferson came into office. He ran against the Sedition Act, which he thought was unconstitutional. And he comes into office and he says, I'm going to pardon everybody who's in jail who's been convicted of violating the Sedition Act because the Sedition Act is unconstitutional. It's no more constitutional than a law that required us to worship a golden calf would be constitutional. And so he pardoned all these people. But that's not the only thing he did. He also halted all existing prosecutions for violations of the Sedition Act. He said, I can't enforce this statute, and my attorneys aren't going to enforce it either because it is unconstitutional. That's him basically saying there's a law in the books. It predates my administration. I'm going to have nothing to do with it, right? And that's a refusal to enforce. That's a refusal to enforce. And since then, other presidents have done similar things. They've refused to enforce statutes. It's more often the case that they refuse to enforce statutes on the grounds they're unconstitutional when they regulate the executive branch, right? So if Congress says you can't remove someone and the president says, I think I can under the Constitution, they may ignore that statute, right? You might think that's what Andrew Johnson did when he fired the Secretary of War. He may have violated the Tenure in Office Act, but his, I think, view in part was that the Tenure in Office Act was unconstitutional. Other presidents have fired people contrary to statutes. There's the Myers case involving the Portland postmaster, and Wilson thinks, so the statute says you need the Senate's concurrence before you dismiss any postmaster, Mr. President, And Wilson says, no, I don't. I'm just going to fire this postmaster, and I'm not going to comply with the statute that says I need the Senate's concurrence. Mr. Myers, you're fired. There's a case about that, but that case arises only because the president refuses to honor the statute that limits his authority. So, Jefferson was refusing to enforce a statute that he believed violated civil liberties. Wilson and Johnson essentially were refusing to enforce a statute that they thought traduced on their presidential powers. And so that's a situation where the president says, I'm not going to honor or abide or enforce a statute that I think is unconstitutional. Another move that presidents have made more recently is, I'll enforce the statute, but I won't defend it. I'll enforce the statute, but I won't defend it. In fact, I will attack the statute, right? I will attack the statute as being unconstitutional. And that, the most sort of famous example of this is DOMA, the Defense of Marriage Act, right? Where President Obama says, I'm not going to give you your tax break. You think you're entitled to a tax break because you think you're married to your spouse, but the federal DOMA Act does not recognize your same-sex marriage. I think DOMA is unconstitutional, says President Obama, but I'm not going to give you your tax break. And what he's essentially doing is he's trying to make sure that there's a dispute for the courts to resolve. He wants this to get to court, and he wants the courts to resolve it. But he's not defending the statute. Right? He expressly files a brief saying, I'm not going to give them the money. I think the law is unconstitutional, so I think you should strike it down, but unless you strike it down, I'm not going to give them their money. And that's sort of that's sort of splitting the baby, right? Essentially what you're saying is, I will enforce the statute I think is unconstitutional, but when it gets to court, I'm going to tell you why I think the plaintiff is right. Right? So you have this weird situation where the plaintiff goes into court and says, Your Honor, the statute's unconstitutional, and the government rises and says, Your Honor, they're right. Right? And then the court's thinking, well, why is there a case here? And the response is, because we're not going to give them their money until you tell us we have to. And then other people, in the case of the DOMA case, the House intervened and made arguments for why it was constitutional or not. Well, you're seeing that happen more and more, right? And you're seeing it happen in the states as well, where attorneys general are saying, I'm not going to defend a gun regulation, or I'm not going to defend some other rule that I think violates the constitutional rights of individuals, right? You have Democrats doing this with respect to Republican legislation, and Republicans doing this with respect to Democratic legislation. And I think you're going to see more of this refusal to enforce and refusal to defend in the federal executive, right? It's a way to score points with your base, right? You think there's a statute that's problematic, you just say we're not going to enforce it or we're not going to defend it, and your base likes that. Right? They like that. They agree with you that the statute's unconstitutional. Right? If you favor gun rights and you think some federal statute is unconstitutional, maybe your political best bet is to say either we're not going to enforce it or we're going to enforce it but we're not going to defend it. Let someone else come in and defend it, and we will signal to our base that we share their view of the Second Amendment or the First Amendment or whatever amendment we're talking about. So there's this sort of semi-new phenomenon of refusals to enforce and defend, and that affects the Constitution, right? It affects our conception of it, right? The fact that the president was coming into court before the Supreme Court and telling the justices, we don't think the statute is constitutional, which is very sort of a rare thing for the president to do, you might think affected some justices on the Supreme Court, right? Most of the time, the executive branch takes the position that if any reasonable defense of a statute can be made, we will make it. Full stop. In that case, they took the position that we will defend any statute where reasonable arguments can be made, except where the president thinks it's unconstitutional. Well, I mean, that's a fine principle, but if the president thinks a lot of statutes are unconstitutional, that will have a great effect on what types of statutes you're going to defend in court, and indeed, it might have a great effect on what types of statutes you're willing to enforce or abide by. So that's the various ways I think that presidents sort of affect the shape of constitutional law. I will end very quickly because I don't know how long I've been talking. Do you know, Bill?
I think you've been talking about 40 minutes.
Oh, okay. Well, this is good. I'll just say this in the last minute and we'll just move on. I didn't mean to talk that long, so I apologize for keeping you. I have students, they just get up and leave. So, and I don't mind, because if they've got to do something, who am I to say don't do it? So, should presidents have this much sway over the Constitution? It's sort of change over time. And I want to say, at least, in a provocative way, why not? Why is it, if we're going to have constitutional change outside of Article 6, outside of the formal amendment process, why must it be by majority vote in the Supreme Court, right? Why must it be a feature of past majorities, right? I mean, essentially, the court is filled with people that reflect past eras, right? And I like them, some of them. I clerked for Justice Thomas. I love him. But why are they better at deciding what the Constitution ought to be understood to mean today than, Obama or Trump or Clinton or, Rubio or who have you, or the members of Congress? It's not obvious to me, right? If you believe in a living Constitution, why you would want the court to be the ones to decide how the Constitution is going to change over time, as opposed to the political branches, right? And so I'll leave it at that, and I await your questions. Thank you.
Sai, thank you so much. And I'm going to start by thanking Sai for having introduced himself to me in my first weeks on the job, which is now 2 years ago. I arrived, and shortly after my arrival, a copy of Sai's book appeared in my office saying, and we have a couple mutual friends. I've lived here in Charlottesville, as many of you know, for quite a long time. I had heard a lot about Sai, but his book appeared, and I was delighted. And Sai is the first senior fellow that we've made here at the center. We have this new title, and I wanted to do this as a way of bringing some former practitioners in, but also faculty across the university that we want to more deeply affiliate ourselves with. And so I'm really honored that, Sai, you reached out to me, and honored that you agreed to be our first senior fellow. So I just wanted to thank you for a great talk.
The honor's all mine. The honor's all mine.
So cue to the audience. I'm going to ask 4 questions, which means after the 4th, you're going to ask questions. And we're going to do these pretty rapidly. The first question that I have is a little bit picking Sai's brain as a scholar and a historian, which this book is terrific, by the way. I read it, and it's great. And I'm a lapsed political scientist, but 25 years ago when I wrote my dissertation, it was on very similar topics. So he had me at the word go when the book came in. So the first question is in that regard, and then guise, and the second, third, and fourth questions are about both his role as a scholar, but also somebody that worked on the Supreme Court for a justice who is an originalist. And so hearing your take on these 3 questions. So after the 4th question, it's your turn, so be prepared. The first is on the president's role over the course of history in the amendment process itself. You talk about the president not signing these things, but presidents have been involved in initiating, instigating, creating a movement for constitutional amendments. If I'm remembering the numbers correctly, I think it's the 11th Amendment that deals with the problem of the election of 1800, where the rules of selection for the vice president were not adequately figured out. And in the famous play, Hamilton, after we get this tie between Jefferson and Burr and it finally gets resolved, Burr says, "I look forward to working with you," and Jefferson sort of laughs and says, "Oh, we're going to fix this thing that makes you my vice president. You campaigned against me, and now I'm stuck with you." The 13th Amendment, as I think, if I remember correctly, Lincoln, in the months before the end of the war and his assassination, raises the idea of amending the Constitution to address the issues of slavery as a way of locking in the North and the South in the final days of the war, that this is what it's become about. And there's no turning back. It's going to be about slavery. And to today, when I think it's often now forgotten, considering all the other things going on in the last few weeks, Donald Trump said that one of the things he wants is an amendment to the Constitution with strict term limits for members of Congress, which is another potential assault against Article 1, against Congress from the executive branch. So I am curious to hear your thoughts about that role. Those are the 3 that just come to mind for somebody that's a lapsed political scientist and political historian. is that a role that presidents have played effectively, identifying flaws in the Constitution and formally proceeding? They seem to have fallen off in recent years. We haven't had a lot of amendments to the Constitution. Just your general thoughts about the president's role in the formal initiation of amendments.
Right. So just a minor correction, Bill.
Get me
The amendment you mentioned first is the 12th Amendment, not the 11th. The 11th Amendment is some obscure provision having to do with the judicial power that my colleagues spend a lot of time on, but none of you will be interested in. But the 12th Amendment, fixes this problem where you're now voting for the president and the vice president separately, whereas before you just voted for two people for president. And when you had the advent of parties, and what that meant is that all the party men voted for both people, and so both Burr and Jefferson had the same number of votes, and so neither one was going to become president until it went to the House. And then in the House, the Federalists, basically played games and wouldn't give Jefferson a majority, even though it was clear from, the context that people wanted Jefferson to be president and not Burr. And that's what, after that is where the Democratic Republicans, the Jeffersonians decided we need to fix this because we don't want to have another replay where the president, the two Democratic Republican candidates get the exact same number of votes. No one has a majority, so it gets thrown to the House, and then shenanigans are played, right? Because I think there are 35 votes in the House, and in 35 votes, that no one candidate has a majority of the states, and people are kind of tearing their hair out because people are now thinking, what if they never get what if no one gets a majority in the House? Who's going to become president? And people are, worried that John Marshall will become president, that the Federalists will somehow continue to prevent Jefferson from getting a majority, and they'll put a Federalist into the White House. And so they do pass that. I mean, I think Chase, in his quote from Hollingsworth versus Virginia, went too far in saying that the president can't propose amendments. Because as I said, Vladimir Putin can propose amendments, right? I mean, anyone can just write to a member of Congress and say, here's an amendment. What I meant in discussing that is the amendment's not presented to the president for his signature. And you could take sort of two different things from that. Well, why would you bother? It's a 2/3 majority in both chambers anyway, and so it's going to pass anyway. But what they thought of in terms of presentment was, well, the president will have objections sometimes, and they will think about them, and maybe that will move them, and then they won't pass the bill again, right? Or it won't have the supermajority the second time. So you can imagine, right, theoretically, that if you gave amendments to the president can come up with some great reason that he didn't publicly announce before, and that changed people's minds, and then on a repassage it didn't go anywhere. But that's never been the practice. And so all I was referring to is it's not formally presented to the president for his signature. And if it's not given to the president, and if the president never signs it, it's still an amendment anyway under our practice, right, and under the Supreme Court case law. In terms of them being effective at amending the Constitution, my personal perspective is we've had a lot of constitutional change outside of Article 6. And so the question is that a good idea, right? To basically amend the Constitution through judicial decisions or practice and then make it sort of almost impossible to formally amend the Constitution via Article 6. And my answer is no, right? It's got everything backwards, right? We should have a more sort of orderly and reliable and possible process of amending the Constitution, so we don't have to resort to these sort of more what I will call sort of less legitimate means of amending the Constitution. But to do that, we'd have to amend the Constitution, right? I mean, and that's hard, right? It's hard to amend Article 6. We've had only 27 amendments over 200 years, right? 200 plus years. You could think that's astounding because it suggests continuity. But if you look at our doctrine, the doctrine is incredibly different, right? We don't have the same Constitution. Those aren't the only amendments that we have, given the changes in our constitutional understandings over 200 years. We have more than 27 amendments. But if you read the Constitution, it looks like we only have 27.
That's a great answer. So the three questions focused on your time on the court, as well as your views as a scholar. One is, from the court's perspective, how much deference is given to the Solicitor General, the president's lawyer, when making arguments about the Constitution and the executive's role in constitutional standing? So just a few examples from history that jump out. Jefferson faces one of the first great constitutional questions. Does he have the authority to sign the Louisiana Purchase and execute it without congressional approval? He's sort of tortured by it, actually. He doesn't think he was a big opponent of excessive, of an imperial presidency, yet he sees this huge opportunity to buy Louisiana for a song, and he decides that he doesn't want to lose the opportunity and just goes ahead and does it. Madison, as you mentioned in the war, backs off using the executive branch, doesn't provoke any constitutional crises. There's secession potentially going on. Obama, in the war with Syria, backs off acting from an executive perspective. He wants to send it up to the Hill. But had he done that, and had he been challenged, and had he argued for it, would the court provide deference, give deference to him?
Yeah, well, so I want to make it clear that I was never on the court. I did not have time on the court. I was just a lowly clerk, right?
But you saw how the sausage got made.
There was no meat in that sausage. It was very pretty. So I think you are right that the court takes the SG very seriously, at least in the following respect. If the SG says that the court should take a case, the court tends to take it. So I don't know, many of you may not know this, but the court's docket is mostly discretionary. They get to decide, for the most part, what the cases they're going to hear. They get thousands of petitions to hear cases, and they only grant 80 of them. And if the SG recommends that they grant a case, they are really likely to grant it. Now, are they likely to side with the government? That I'm not as certain about. But if the SG says you should take this case, it's important to resolve this issue, the court almost invariably acquiesces to that recommendation. So the SG is important. There's a separate question that, when the SG takes the position, does the court follow it? And I don't think the court is as deferential as to that, right? It's one thing to identify an important question. It's another to defer to the resolution of it. And I guess it could vary from justice to justice, right? Whether they are willing to side with the SG more often than others. But I don't know of any study which shows that Justice X is more inclined to follow the government's position as expressed in the SG's brief than Justice Y. I wouldn't be surprised, right? Think of Justice Rehnquist. Justice Rehnquist was a sort of a big government conservative. He thought that the government could do lots of things that some modern conservatives think they couldn't, right? In the free exercise or First Amendment area, and that I think would mean that if the government was defending some statute, he might be more inclined to uphold it, but not because the government was defending it, but because he just thought the government could do more, right? So if you think the government has lots of powers, you're going to be more inclined to agree with an SG who says whatever the government did here was constitutional, but it's not going to be clear whether you're doing so because the SG is saying it or because you independently think that. On Jefferson's Louisiana Purchase, I actually think Jefferson went to the Senate. He got the Senate's approval. What he had a concern about is whether the Constitution, I think, permitted the government to acquire new territory. And I think he said no. The Constitution doesn't permit the government to acquire new territory. But that was just crazy wrong, right? Everyone in his cabinet said, you're wrong about this. We can give away territory per the Constitution. If we lose a war, we're going to have to give away territory via a treaty. Treaties are used to acquire territory and to give up territory. Why would you read the Constitution as not permitting that? And I think his sort of background was, I'm a sort of strict constructionist. I'm going to read the Constitution very narrowly. It doesn't say that we can acquire territory. Therefore, treaties can't be used to do that. And so what he was saying essentially is, I'm going to do something that's better, that's best for the country, even though I know it to be unconstitutional. But I don't know anyone else who thought that. And he said he was going to go to Congress and get their sort of approval. What he meant by that is he was going to confess constitutional error. But he never did that either, right? He just kept quiet about it. So maybe he was convinced that he was wrong, right? Because I think his whole cabinet said he was wrong. And I think he was wrong. I don't think the Constitution prevents the federal government from acquiring territory. It certainly doesn't say so expressly. It's got to be some implied restriction. And then on war powers and, and Libya, it's established doctrine now that Syria, sorry. Did I say Syria? I meant Libya, right? So there's the Syria question about the AUMF and its application to ISIS, but there's also President Obama's war in Libya, which isn't part of the AUMF against Iraq, and it's not the Al Qaeda AUMF either, right? No one said Muammar Gaddafi is part of Al Qaeda. No one said Iraq's part of Libya, or Libya is part of Iraq. But whatever the case may be, the courts, for the longest time, have not waded into these disputes about war powers. They've either said no one has authority to go into court to question these military overseas adventures, if you will, or it's a political question, meaning the courts won't resolve it. And so, when lawyers look at these questions, they assume that the courts will not get involved. And so if you're the president, there's not going to be a case about whether your military action against Gaddafi is legal or not. You pretty much know that. They'd have to change the doctrine, but it hasn't happened yet. Right? Members of Congress have tried to sue presidents saying you can't do this, and those cases are always thrown out of court eventually.
So there's been an evolution, Sai, and I'll start with the question and then talk about the evolution. The question is the court uncomfortable with the executive branch doing more rule writing and less legislating? The evolution is, as you pointed out, back in the days of Washington and Jefferson and Madison, there was enormous executive deference to the legislature to actually write the law, and they would execute it. It evolved then to the executive taking the lead by introducing legislation or working with the Congress to craft legislation, and almost an expectation that the executive, particularly after an election, would come in with an agenda, such as the New Deal. And now, because of political gridlock, you now have the executive more and more on things like climate change or even Obamacare, writing the rules after a big piece of legislation is done for years afterward, writing the rules, because actually, I'm not talking about a constitutional amendment, I'm talking about a legislative amendment to a particular piece of legislation is so hard to get done. Right. Is the court uncomfortable with that? Them having to get into the business of deciding where rule writing is or is not constitutional?
Well, I think the rise of what we might call executive legislation, is a function of two different phenomena. One is Congress explicitly giving the executive branch or the independent agencies rulemaking authority. So there are tons of statutes that just say, regulate this area in the public interest, right? Regulate the airways in the public interest, with sort of nothing beyond that. And it's sort of carte blanche in that case to the Federal Communications Commission. And you can repeat this across agencies, the EPA, the Securities and Exchange Commission, the Federal Election Commission. They all have broad rulemaking authority. And the court in the New Deal struck these down as delegations of legislative power. And they said Congress can't delegate legislative power. The Constitution says that Congress has to exercise legislative power. They can delegate some discretion, but they can't delegate, en masse the legislative power to these agencies. But ever since then, the courts have never found a delegation of authority to the independent or executive agencies as violating this principle. In part because the courts are reluctant to say what sorts of delegations go too far, right? How much is too much discretion in the hands of the executive branch or the independent agencies? And they don't have a formula for figuring that out. And some of them don't trust themselves to do it. But part of it's also sort of maybe ideological, right? If you believe that the modern state requires lots of legislation, and you don't think that Congress is able to provide that legislation, you will then want other people to provide it, and those other people will be these administrative agencies, right? So, some people who defend these delegations will say members of Congress don't know anything about federal election law or communications technology, right? And securities, the securities exchanges. They need to delegate to experts. And if they had to make all these rules themselves or approve all these rules, we would have fewer rules, and that'd be terrible. We need to regulate communications. We need to regulate securities and exchanges. We need to regulate federal elections. I mean, there's just tons of these agencies that are regulating this way. And so some people say we need to have them in order to have rules for a modern society. Congress can't do it. But what you're talking about is something slightly different, which is, well, what happens when the executive branch goes beyond, or arguably goes beyond, the scope of the delegated rulemaking authority that Congress gives it? Because they're not literally saying you can do whatever you want. They say that you can do A, B, and C, but then they say don't do D, E, and F. And then what if the president does something that looks like D, E, and F? Who's gonna do that? And what's the court's response to that? And I think, as you'd expect in a multi-member institution, different justices have different levels of comfort with that, right? So someone like Justice Thomas doesn't like the vast amounts of delegations to executive branch agencies because he thinks Congress ought to be making the rules, or at least approving them, rather than having essentially lawmaking go on in these agencies. Someone like Justice Breyer thinks that's fine, right? He believes in expertise, and he perhaps believes it's a good idea to have more of these regulations rather than less, and it might be a consequence of you might have less if Congress had to approve them all. And then, as to your point, I think it has to sort of vary by issue, right? Republican presidents and Democratic presidents are equally able to misconstrue statutes and seize authority that isn't granted to them by statute. And you can't say in the abstract that some justices don't care about that, and other justices care about it deeply. I think they all stand ready to stop a president who is doing something they think is impermissible. They just might have differences of opinion as to when presidents are going beyond the scope of delegated authority in particular circumstances, right? So the immigration rule, right? I think there are probably some people who think President Obama went too far, and others who thought it was probably fine. But that's not unusual.
Okay, last one, and this is a pretty quick one. Newt Gingrich said a few weeks ago, the President of the United States can pardon pretty much anybody in his administration. So what that really means is executive branch officials can more or less do what they want, and the president will pardon those people.
Yeah.
Is that a fair interpretation? How
So
expansive is the power of the pardon?
Well, look, I think the president could go, into his office tomorrow and let out everybody from prison, right? And he can not only do that, but basically said basically blot out their crime, right? Marshall said that about the pardon power. It's as if you never committed a crime. And that hasn't happened ever here, but it used to happen, at least in part, right? When kings came into office in England, they would have a pardon for, most of the people in jails because they wanted to celebrate the fact that they were king. And Washington did this as commander-in-chief, right? When the anniversary of the French alliance occurred, or the Declaration of Independence, he'd pardon a bunch of people, lots of people. And some people thought that was a good thing, right? To forgive people and give them a second chance and wipe the slate clean. But that hasn't happened in modern times because presidents are afraid of Willie Horton, right? They're afraid of pardoning someone and that person doing something, and then someone saying, why did you pardon them? And so they instead pardon, financiers who've given them money, or do other, things like, or pardon, their friends in the administration, perhaps. So I think the pardon power can be used to excuse criminal conduct, even by the president's close associates. People at the founding knew this, and some people didn't like that fact. People said that the president will pardon his co-conspirators and hide his conspiracy. They knew that he could do this. I don't think, if what he means by that is, therefore the president can do whatever he wants, and therefore those people can do whatever he wants, that's not quite right? There are certain rules, the violation of which cannot be pardoned because they don't create a crime or a civil offense. They just create a rule that has to be followed, right? So if there's a statute which says before you issue a regulation you've got to do certain things, and you don't do them, the regulation is invalid, and a pardon doesn't cure that, right? What a pardon would cure is you can't, if you're going to jail or you're being fined for violating a statute, then it can wipe away that. But if there's a provision that says you've got to do certain things before you exercise government authority, you can't do that. So I don't know what he means. If he just means the president can do whatever he wants because he can pardon everybody, that's literally not true. But if what he means is, if the president wants you to break into a hotel, you can do that and be pardoned, the answer is technically yes, right? The president could have pardoned all the Watergate, I don't know, B.B. Rebozo, whoever those people are, the co-conspirators. He could have done that, right? Because the Constitution literally permits him to do that. That's a flaw with the Constitution, but the Constitution isn't perfect.
That was the fourth question. So questions now to the audience.
Yes, it's very
Oh,
interesting.
I think we need people at the microphones.
I have a loud voice.
Okay, please go ahead.
We'll repeat the question.
Okay, great.
You started out with a very interesting definition that the Constitution was living.
Mm-hmm.
And yet the major changes in the Constitution definitely are because of death.
Mm-hmm.
And but it led to me to a question, what is interpretation?
Mm-hmm.
And what is your interpretation of interpretation?
Well, so the question is, you started out by saying the Constitution is living, but the Constitution...
No, you did.
No, I'm trying to repeat your question. So,
The present nominee thinks the Constitution is dead.
oh, that's what you mean, right? So, look, when I was talking up there, I wasn't endorsing the proposition that we ought to have a living Constitution. But I think what I was trying to suggest is, if you look at how the Constitution was understood 200 years ago, and if you look at how it's understood today, it's in fact different. And we can criticize that, and I've criticized it. My talk was really meant to show how the president's been involved in changing the Constitution over time in terms of how it's actually applied in practice. It's not necessarily meant to suggest that's a good thing, but it also is meant to suggest as a descriptive matter it's happened, right? Like, I don't like to break eggs, but sometimes they get broken. And I'm sort of telling you that the president's sometimes involved in breaking them. And then I'm further suggesting the court is sometimes involved in breaking them. And the final 1 minute of the talk was, why is the court better at breaking them than the president, right? But I'm not defending the practice of breaking eggs in the talk, or more generally. I'm just saying this has happened, right? Whether we like it or not. And then we can either try to stop it from happening going forward or going back to what it was before. But the talk wasn't about saying this is a good thing, right? I don't think it's a good thing, but that wasn't my talk. But thank you for the question.
Well, what is interpretation?
That wasn't part of the talk either, but what I would say is interpretation, I think, involves a communication from one person to another person. In the case of the Constitution, it involves understanding what the people who wrote the Constitution were trying to accomplish. And if you're really trying to understand what they were trying to accomplish, understanding what they meant by the Constitution, not what you would have it mean. But that is a minority position, right? Maybe I'm the only person who believes it. Maybe you and I are the only people who believe it, right? Maybe you, I, Justice Thomas are the only people who believe it. It's not a position that commands a majority of the country. I think there are problems with the other position, and in my writings I've sort of explored them. But that's what I think interpretation is, right? I think it doesn't make sense to say, we take the words from the Constitution, but we infuse them with our own meanings. Because I'd say, well, why bother taking the words? If we're going to have, the words mean whatever we want them to mean, let's just not bother with the words. Let's just start with new words, right? I think that's sort of, there's an incoherence there. But I have colleagues at my law school who tell me I'm totally wrong. So maybe I'm totally wrong.
Well, I am not here to do that. Instead, what I want to do is thank you for kicking off the series topic of the President and the Constitution with such an excellent and provocative conversation and lecture today. I was particularly taken with one of your concepts of the jawboning president attacking the court. And I'd add to your list of the Democrats who've done that, Richard Nixon in 1968, and using that as a key component of his presidential race and his campaign, particularly with the Southern strategy. And then that puts me in mind of Richard Nixon in the court as he came to what would be the end of his presidency, and the U.S. v. Nixon case about release of the tapes. And the fact that he had said that he might not follow the court's ruling in that instance. Could you talk a little bit about the constitutional roles of the courts, the federal courts and the president, particularly the Supreme Court and the president, in your concept of separation of powers, and what happens if a president says, I'm not going to follow what the court says I have to do? In that instance, we know that the political role took over on Capitol Hill with the other branch of government, namely the Congress, and impeachment and near conviction. So thanks again, Sai.
That's a great question. I mean, I'm sure that would never happen today, where a president would say he wouldn't follow the court. But he's not the first to have said that. Roosevelt also drafted some documents where he said, the court's out of control. We've got to now go forward and just sort of ignore the court. So other presidents have thought about this. Andrew Jackson has supposedly said about a Supreme Court case, the Supreme Court has decided this, and it's going to have to enforce it somehow, right? I think he may have said the decision of the Supreme Court is stillborn. Basically, we're not going to do it. We're not going to move a finger to enforce it. And so it's sort of happened before. I mean, during the Civil War, Lincoln ignored Taney's opinion in ex parte Merryman, right? There's this habeas corpus suspension by Lincoln during the Civil War. The Chief Justice of the United States writes an opinion while writing in circuit saying the president has no authority to suspend habeas corpus, release the prisoner. And, the military and per Lincoln just says, we're going to ignore Taney. Right? We're not going to pay any attention to his opinion on this fundamental civil liberty. I think Taney was right. I think Lincoln was wrong. I happen to prefer Lincoln over Taney, but I think Taney was right and Lincoln was wrong on this question. So that there have been times in our history where presidents have sort of either threatened to ignore what the court has said or ignored what particular judges have said. I think the Constitution, as originally understood, didn't permit that. I think in order to understand that, you have to start before the Constitution. In England, it used to be that the king sat as a judge, right? The King's Bench in England was called that because the king sat in judgment. And over time, the king stopped doing that. And over time, the judges got tenure during good behavior, which meant the king couldn't fire them if he didn't like their judgments, which meant when they issued judgment, the king had to follow it. And they had this idea, in England of a separation of powers, right? The judges decide these cases, and the crown has to follow them. And I think that's the understanding that got transplanted into America because we were basically an English colony, right? And when we have a judicial power and an executive power that's separate, and it is separate in the Constitution, I don't think it's up to the president to relitigate a case in his own mind and decide not to follow what the court said. If there's a judgment, the executive branch has to abide by it. If there's a judgment, the executive branch has to enforce it, even if it's not a party, right? If it's, Barbara against Cy and you win, and the president thinks, Trump thinks that I won, it doesn't matter. The marshals have got to, give you the judgment. And if it's Cy against Trump, and I win, the president has to, I think, acquiesce to that as well, even if he thinks the court got it completely wrong. I think that's an implicit feature of the Constitution. The Constitution nowhere says that, but the separation of powers between judicial and executive, I think, makes no sense unless you suppose that, because what's the point of having judges if no one has to pay attention to what they say? They're law professors, right? They're no different than law professors. They issue opinions. Having said all that, there's the separate question, I'll say this very quickly, there's a separate question of what to do with the opinions. Right, there's the judgment of the court which decides who wins or loses, and then there's the opinion that explains it. And there's a long tradition of presidents saying that the opinions of the court don't bind me, the judgments do. Lincoln said this in respect to Dred Scott. He said, they've decided this case, and I don't propose that we free Dred Scott, even though I think the case was wrongly decided by Roger Taney, but I don't propose to follow it in future cases that are similar, because it was wrong. And Edwin Meese said this during the Reagan administration, and this has been said from time to time, and it partially reflects our practice. Presidents don't necessarily take what the Supreme Court says is the law as the law, even as they enforce the judgments, right? So Obama didn't try to enforce the penalties against Citizens United because there was a case saying that they won the case, but it seems like he was basically saying, I'm going to resist it going forward in some way because I think it was wrong. And so I draw a distinction between the judgment the court issues, which decides the case, and the rationale they give for deciding in a particular way. I don't think the president is bound to treat the opinion as if it decides what the law is. But other people have differing views on that.
Boy, that's a great answer. Can I ask people to go to the microphone in the back, just because we are, I think, live streaming this, and this way our audience out there in cyber world can hear your questions. And the race to the microphone is finished. Please.
So that's an interesting question. If, let's say, this immigration business, the court says something's illegal, and the president decides, well, I don't care what they say, and there's a lawsuit, and it goes to the Supreme Court, and they come down with a decision, and the president still says, well, I'm not going to do it.
Right.
Now what happens?
Well, I think what you're asking is, what if the president refuses to abide by the judgment of the Supreme Court and continues to enforce an executive order that the court has said is unconstitutional? And I don't think the president would do that, because I think what he would find is that the country would quickly conclude that that's a mistake. I think the court's decision would have to be so out of bounds, so sort of unrecognizably coherent or incoherent, that for the president to want to do that. So Nixon threatened to not abide by any subpoena that was issued for his tapes, but as soon as they issued the subpoena, he complied, because I think he realized that if he didn't, he was going to be impeached. He was going to be impeached anyway after they came out, but this made it a little less likely, right? Or maybe it extended the period of non-impeachment. And I think enough Republicans would turn on Trump if that's what he said, because I think it's a bedrock, if implicit feature of American constitutional law, that if the Supreme Court tells the president to stop doing something, that the president isn't going to say, you and what army, right? How many divisions do you have?
He chooses not to defend or prosecute.
Well, I mean, you're talking about the immigration order, or are you talking about the other order? Which order are we talking about?
Any order that the Supreme Court says you have to do something, and the president says, I'm not going to do it. He can't be arrested and put in jail.
Yeah, so that's well, that's an interesting question. I think the context matters, right? Because I think in the context of this order, it matters to me at least. I'm not sure what if it matters to you, but in the context of the president's executive order on immigration, if he continues to apply it when the court says it's unconstitutional, I think your question is, well, what can they do to him? And I think that is an interesting question. My response is, even if they can't put him in irons, right? What's going to happen, I think, is that the country will rise up against him, and it doesn't matter how many divisions the Pope has if you think the Pope, has a direct line to God, and you're willing to fall on your sword because he does, right? And so if enough people, are going to rally around the Supreme Court and say what the president has done is unconstitutional, that will matter for the president, right? And then they will perhaps impeach him and remove him. So he doesn't have to be put in jail or found in contempt for that to happen. It's not. I mean, I don't know. It's not obvious to me why he couldn't be found in contempt. The court has never said he couldn't, right? The court has said that he can be subpoenaed. If you say that, you might think that he can be found in contempt. Now, does that mean he can be put in jail? I don't think they'd ever try to jail him, because I think there'd be a problem.
Right. You think that essentially the retribution is not
legal, it's political.
Exactly. That's
Right.
exactly what I was
That's
going to
right.
say. And legal in the sense of the arms of the law, literally law enforcement. It's political enforcement, not
Well, sure,
legal
that's right. I
enforcement.
mean, when we think about enforcement of the Constitution, we often think about the marshals and the justices, but a lot of it's political, right? All this stuff about the emoluments clause, that's never going to court. It's only going to be enforced by Congress, if at all, in public opinion. It's never going to go to court. I don't think anyone has standing. And there are lots of provisions that work this way where it can never get into court. I see my neighbor Georgia's here. I did not know you were here, Georgia, till just now. I'm sorry to embarrass you like this. But, you know, when I look out into an audience, I kind of like, you know, I'm not sure who's there. Now I'm wondering if my kids are here somewhere. I don't see them, but
So we're coming right up to 5 o'clock, but I just want to see if there were any final questions. I could go on at least until 8 o'clock when the basketball game starts. But any final questions from the audience before we thank Sai and let him get home to his kids? One last question, please. Yeah, please go back to the microphone.
So, as I understand it, the president has the right to appoint the next Supreme Court justice, as Obama tried to, but then Congress refused to review. Right. So, could he have taken that to the Supreme Court, or where could that have gone?
Well, that's a great question. Can the president take separation of powers disputes to the courts, right? You wouldn't take it to the Supreme Court. You take it to some district court and ask for a declaratory judgment. I asked my judge this one day, and he thought I was crazy to ask it. There's never been a case where a president, I'm not saying you're crazy to ask it, I think it's a natural question. Because I asked it too, right? And we're both smart. There's never been a case where the president has gone into court and said, this statute or this inaction on the part of Congress violates my constitutional powers, and I want a declaratory judgment that it's unconstitutional.
And then when the Congress goes into session, he could have just appointed, right?
Well, Congress never went into recess, right? That's the Harry Reid gambit, right? They never went into recess, so we couldn't recess appoint Judge Garland. So in my book, I say that was unconstitutional. But this is an originalist book, and we're not in an originalist world. The way it's worked out since then is both sides stall. This is not the first time this has happened. It's the first time it's happened to a Supreme Court justice for this period of time. But you know, there are circuit court judges or nominees who had to wait 2 years and never got a hearing. So this has just been going on, and you know, it just happened to happen in the context of a Supreme Court nomination. But the Appointments Clause doesn't treat Supreme Court justices differently. So, I mean, you know, it's tit for tat, right? And this was the time for tat. Tit already happened, I guess, right? So, but we'll go on.
I was going to say, so with the current nominee, can Congress filibuster for 2 years?
Well, I mean, they could filibuster. I mean, I think, you know, practice doesn't give you clean answers, right? Like the practice for Merrick Garland doesn't say, oh, it's only for a year, right? Or it's only in the last year. You can draw anything you want from practice, right? You could say it's only in the last year of a presidency, or no, it's, you know, it's indefinite, right? We can do this for 8 years if we wanted to, right? There's just because there's nothing written down, right? It's not like they said, now that we did this, let's memorialize this in writing and say what we did, right? And if you ask, you know, Mitch McConnell, it was the last year rule, right? It was he calls it the Biden rule because Joe Biden said this once, right? And if you're the Democrats, it's, you know, all hell is breaking loose, right? You have no, you know, you're not applying any rule, and you can do this now indefinitely. It's not going to happen, I think, now because the Republicans control the Senate. But if the Democrats did, of course they could say, you know, we're not going to do this for 2 years. They've already done that, right, to certain nominees who they, you know, didn't want to hold hearings on for whatever reason. Could they do it for 8 years? Yeah, it's possible, right? I mean, there's a quote from a British lord, and he says, you know, a functioning system depends on the various, you know, branches not pressing their powers to their logical limits. And what he was basically saying is, you've got all these powers in your powerful institutions, but if you really sort of use them whole hog, the system won't work. If Congress just chooses not to fund the executive, and the executive chooses to not fund Congress, the whole system falls apart. That can happen, right? The president can say, I'm going to veto every single bill, and Congress will say, we're not going to fund the executive branch. That could happen, but that's, you know, the system won't work if that happens. And, you know, if you come to the we're never going to confirm anybody because we don't like the president, which some people thought was essentially what happened in the last administration. If you continually do that, that will lead to a gridlock of the worst sort.
Sai, thank you so much. Thanks for first being a part of the Miller Center. We're delighted to have you for this terrific talk and for fielding our questions. And we look forward to not only having you a big part of our family, but as we all navigate these choppy waters. I think E.J. Dionne here said yesterday, it's the first time in his memory that people started talking about impeachment during a transition period. Now, the history on that may not be true, but if that's any indication, we're going to have some very interesting times in inter-branch relations over the next set of years.
We're in the right business, Bill. Thank you. Thank you for having me. Thank you for having me.
Thank you all.